pretrial date, June the 26th, 2023 at 8:30 a.m., all right?
And Your Honor, we have one other question. He believes that he has a court date for another case today. Is there any way the court could direct him to the right courtroom?
I can.
Thank you.
No, I'm not. Let's see here. What is courtroom? Judge Jefferson's courtroom is,
Is it 439?
I don't know, it's 439, 439. So dial 439 instead of 434, Mr. Bruce. All right, Lamont Harrison Lemon, the second.
Both of the devices in here for that, because I believe there were two devices.
That's the gentleman with the fez hat on, headgear on. Can you unmute yourself, please, sir? Is he connected to audio?
It appears.
Lemon Bay, Harrison Lemon Bay. Can you hear me, sir?
Can you hear me?
I can hear you. Good morning to you.
How are you?
Okay. Are you the second or the third?
I'm here on behalf of the third.
The third. Okay. And I guess it's the second. That's right. This is the city of Detroit versus Harrison Lemon Bay the third. Straight that. This is the state of Michigan versus Harrison Lemon Bay the third. Case number SX4195968. Counts 1 and counts 3. Appearance for the record, please.
O.S. Berry Jr. on behalf of the defendant. State your full name, sir.
I think he's representing himself.
Your Honor,
Yes. Yes. And add count 3 to that. Add count 3 to that record as well. Or count 2 to that. Or 1 to that record as well. So count 1, 2, and 3. We have that other. I believe. State your name for the record, Mr. Lemon the third.
yes, I am Harrison Lamont Bay, all lowercase letters. And I'm here on behalf of Harrison Lamont third.
But I've never heard of the all lowercase letters. What does that mean?
It means that the name is to be spelled with all lowercase letters, not all capital letters, not part capital and lowercase, strictly all lowercase.
So today is the date and time set for a pretrial in the matter. How do you want to proceed, sir? I know you filed some documents with the court, and I did have those up in my chambers. But how do you want to proceed?
Your Honor, I'm the surety on behalf of the principal debtor, Strawman Harrison Lamont III. I've given the court notice weeks in advance. I'm here to tender a special deposit to the court and make the court fiduciary, the prosecutor, as well. And I'm looking for a plea of release today. Will you grant a plea of release?
No. I can grant you a pretrial. I can grant you the opportunity to speak with the city attorney, or I can grant you a trial date by judge or by jury.
Yeah. So
what would you like to do, Mr. Lemon Bay?
Well, you mind if I ask a couple of questions? Just want to make sure that I'm comprehending it.
You may.
All right. So, as you gave the name, I heard you mention a few different names. I heard you mention Harrison Lamont Bay the third, and then Harrison Lamont the second, and various different names. I just want to make sure that I'm clear on who or what it is that we're here to discuss, because I don't want to speak on behalf of.
It does have an error. It does have an error. There appears to be an error on the computer here. So entry date. One of the counts was entered into as one count was entered into as Harris Lemon the third. The other count was Harris Lemon the second, and the other count was entered Harris third Lemon. So I think that's just a typo. There's the nature of the offenses is the misdemeanor case is driving without a valid operator's license, no ops on a person. And that is a 93-day punishable by a maximum possible penalty, 93 days in jail and/or $500 in fines. And you have two civil infractions, one expired plates, and the other one speeding at 16 to 20 miles an hour over the speed limit. So those are the nature of the charges. I'm going to offer you an opportunity to mitigate this by taking the better driver's course, sir. I'm going to put that in the chat if you choose to, and I can give you time to do that. If not, you can set it for a trial day or whatever you're. Set it for a trial date or speak with the city attorney today. What would you like to do?
I'm really, again, I'm ultimately I'm here to tender special deposit and settle the charges. Make the court fiduciary.
You settle it by pleading to taking a plea today, paying the fines, or taking it to trial. See if you can do better at trial. You have a right to it. a jury, and that's it.
Your
Those
Honor,
are your only options, sir.
I'm looking for a clear release. Are you stating that there's no offer of equity in this matter, Your Honor?
I don't know what you're talking about. All right, we're
Sir,
gonna move on, so I don't have time for this.
Would you like to speak to an attorney? Would you like to speak to an attorney, sir?
I don't. I'm
You don't?
not for counsel.
Okay, well, we're gonna pass the matter, and we're gonna move on, and he can just watch and see how it works in here, because I have too many people that are waiting that want to be heard and hear their claim, and I don't understand what you're saying. I've given you your options, and you can sit back and ponder those. I'll give you time to ponder those options. Other than that, sir, I don't know what else to tell you. All right, let's move on. Next time. No, I've already answered the questions I'm answering. No. Please mute your device, and you either take the offers that I've given you, speak with the attorney, or take the deal, or set the matter for a trial date. Those are your options.
Let me set the matter for trial.
Set the matter for trial. Okay. I'm going to give you a trial. You want trial by judge or jury, sir?
Your Honor, by jury.
Okay, jury trial. Can I get a jury trial date, please? Soonest one you have.
December the 29th, is that right?
There's no deal. This is the earliest one you have.
I jumped. It's only like June.
June the 2nd.
I'm seeing.
All right, June the 2nd.
Or we have 15, we have, right? The next one will be July the 13th. Because we have 15.
Let's do June the 2nd. June the 2nd. We should do this in the afternoon as well.
Or we have some pretrial.
Yes, we'll set a pretrial. So your next court date is going to be a final pretrial, sir. Final pretrial will be June the 1st, 6/1/2023 at 8:30. And then we'll set the jury trial date for the next day. We'll set it at 2:30. All right, we'll have you at 9:30 on June the 2nd. So your next action date that you need to appear is June the 1st at 8:30, and then the next day we'll have the jury trial at June the 2nd, 2023. I have received your motions. If you have any more motions, make sure they're in before the 1st date, and then we'll proceed with picking a jury, setting the jury panel at 9:30 on June the 2nd. If you don't have any further questions, Mr. Lemon Bey, then have a very good day, sir. All right? Good luck to you.
Best of luck to you.
Thank you. All right.
Mr. Kiesel was not on this matter when he came here. So therefore, he's not on this matter now. I do not require the services of the Office of Public Defense. And if he was on this matter, there's never been an interview. There's never been any discovery for it. There's never been any indictment for it. We don't have any copies of the official state of New Jersey certified Essex County public records that were stolen by Matthew T. Dill and are unlawfully held by the Office of Prosecution. We don't have copies of that pursuant to the courtroom rules that I heard you mention plenty of times that stipulate that we're supposed to be giving copies of those instruments, or those original instruments are to be transferred back so that they're not contraband or issued in the indictment. Or listed in the
I'm
indictment.
saying that, but
So I don't have any information relative to this matter, ma'am. So the account numbers that you read, I don't have any information pertaining to them.
thank you, sir.
Just to clarify the record, in proceedings that took place downstairs for Judge Smith, he had removed the Office of Public Defender from representing Mr. L. He then later reversed that ruling and sent the matter upstairs to Your Honor. So, as a point of clarification, when we came up here, you had indicated that, given the fact that Judge Smith had reversed that, or the Public Defender's Office was in this matter.
All right, thank you for refreshing my
Well, thank you.
recollection.
No,
No, sir, I'm talking.
Look, this is not your case.
Well, I'm talking.
Objection. He is
Dear,
not my
dear
attorney.
ACL,
No,
he may not be
not Nobel. Not Nobel.
in your
No.
ACL. Mr. Kiesler is speaking to the court. Whether he's speaking on your behalf or on his own behalf, please extend to him the courtesy that has been extended to you and let him finish speaking.
No problem.
You
I just wanted
will
to
have an
clarify.
opportunity to respond. Please listen.
No problem, ma'am. I just wanted to clarify who he's speaking on behalf of before he makes his
He
statement.
doesn't have to respond to anything that you say. He's speaking to me. Thank you, sir.
This brings us to the next point. Quite frankly, we need to make a motion from our office to be relieved for non-cooperation. When we were representing Mr. L, we had forwarded information on Mr. L was returned to us, Judge. There's no communication between us.
Did you send it to the post office box address?
He sent it to multiple addresses.
Objection, ma'am.
Given the fact that it's clear, Judge, he stated numerous times he doesn't want us to represent him, he will not cooperate with us, Judge. We can't effectively represent someone who does not want us. So if Your Honor requires a formal written motion, I can have that filed within the week. But realistically, Judge, we're asking to relieve for non-cooperation.
Objection, ma'am. I wish that.
What is your objection?
I'm objecting to the fact that there hasn't been any information forwarded to my office stating on record, Judge Smith, I received the recusal notice. No problem. All right, now, if the Office of Public Defense or anybody, prosecution, whoever, stipulates that they forward information to our P.O. box, that's a lie, and we ask for them to present proof of receipt or proof of consent of the correspondence.
Can I ask you a question? Can I ask you a question? One of the things that you say is that you've never received a copy of the indictment.
Exactly.
Which indictment? Are you referring to all three of them?
Whatever information that you have on your desk, I don't have anything.
I can resolve that problem right now. Mr. Kramer, I need you to make a copy of something for me, please. I don't have the old 0302, so make the copies of the ones that I do have. Okay. And then there's another one. Oh, I got something like that.
As well, I don't have.
Sir, please, I'm looking through the file. I can't listen to you and also look through the file at the same time. If you could make one copy of each of these and bring them back to me. Thanks.
Ma'am, while he's at it,
Hold on just a second here.
there's also other information that I'm addressing that he may want to copy pursuant to Rule 313, 3-3, Discovery and Inspection Rule. The prosecutor shall permit defendant to inspect.
May I interrupt you for a moment, please?
No,
May I
ma'am.
interrupt you for a moment, please?
No,
All right, well, let me know when you're done.
For the record. For the record.
All right, the record shall
Bottom line is,
that
public
your
records.
ACL is placing information on the record.
All right, so bottom line is, pursuant to your courtroom rule 313, 3-3, B and C, I believe, I'm not part of society, so I'm not 100% familiar with it. But
Some of it may be unintelligible to you.
according to it, I'm not familiar with it.
Right, I understand.
So, just correct me if I'm wrong, but it stipulates that,
It doesn't stipulate everything.
Discovery and Inspection Rule 3:13, 3-3B, and C, it stipulates the prosecutor shall permit the defendant, if you're claiming I'm a defendant, I've been here almost 8 visits, and this prosecution has failed to prove jurisdiction, and so you. It stipulates that books, handle objects, papers, and documents obtained from or belonging to the defendant, records of statements or confessions, signed or unsigned by the defendant, or copies thereof, and a summary of any admissions, declarations against penal interest made by the defendant that are known to the prosecution but not recorded, books, papers, documents, etc. I'm supposed to be given a copy of that, if not the originals. Those documents are not considered contraband or are not listed in any of the indictments that you may have before you, so I'm either requesting for the return of the original certified documents, the public records that were taken, or copies of those documents according to the rule, which says I have a right to have. I'm also going to address that on the 12th, I believe a week ago, you stipulated that today's matter will be relative to jurisdiction, your jurisdiction or the prosecutor's authority of jurisdiction. You have no jurisdiction and neither does the prosecution, Burlington County, the state of New Jersey, or the United States. So I'm letting you know that now, and I'm asserting that I'm protected by the Treaty of Peace and Friendship via 1787 pursuant to Article 4. You must dismiss this case. For the record, on the record, and let the record show.
I will upload this in its entirety this week. Have a great day, crime timers. Remember to like, subscribe and comment.